Welcome to the Binary Agora. I am your host, Alba Rivera Martinez, and today we are going to be discussing the Court of Justice's ruling relating to the European Commission's case relating to the Google Android case issued on the 2nd of July. And to discuss it, I have with me none other than Pablo Ibáñez Colomo. He's a full professor of law at LSE and also a visiting professor at the college. He also has the greatest mind when it comes to talking about the enforcement of Articles 101 and 102 of the treaty, and he is a regular now on the Binary Agora since this is his second appearance on the show. So welcome to the Agora, Pablo.
Thank you very much. I'm looking forward to many more.
Getting straight into the discussion and the topic of the case. So Google has fought this case nearly for a decade, from the 2018 Commission decision through the General Court's judgment and to this final ruling by the Court of Justice. So can you briefly outline what the main points of the Court of Justice's reasoning lies within this long saga of rulings and all of the ups and downs that have taken place, and what is the aspect that maybe you miss from this ruling?
Yeah, thanks so much, Alba. And I will not say anything about you being overly generous in the way you presented me, so thanks for that too. Let me just take a step back, if you like, about sort of this judgment and the case, because there's typically a mismatch between sort of what the case is about gets argued on appeal in particular. So that is to say, when the case is being discussed at the second instance, right? Then from that perspective, if you allow me just to take a step back, what I found really fascinating, I mean, not having been involved in any capacity in this case and having followed the saga from the outset, I think is the first, I would say, big judgment. It was perhaps the big case dealing for the first time with this much touted issue of ecosystems. Right. So then it's become sort of one of these epithets that gets used all the time. We talk about ecosystems and so on. But the one bit that I found particularly interesting about this case was precisely about that. Right? So then we may talk about ecosystems in different contexts, but here it was an important aspect in that respect. Right? Why do I say that? Because when we're talking about ecosystems, I mean, ecosystems beyond digital, ecosystems in its original sense, we're talking about biology and nature and all the rest of it. The really important aspect about ecosystems is that it is made up of different aspects of different features which interact with one another and which keep the system in balance. So then if you talk to a biologist about ecosystems, I think this is the fundamental aspects that they will emphasize. And that sort of gets lost in competition law and digital regulation discussions for some reason. They talk about ecosystems for different reasons. And when we talk about ecosystems, the question we have to ask ourselves when we enforce the law is, well, what happens when we remove one bit of the ecosystem? How does it affect the balance of the system? And what the European Commission challenged in this case were different aspects of the ecosystem. Why is that important? It's because, well, once you remove one core aspect of the ecosystem, it is at least reasonable to expect that the balance will be altered. And that has implications from a number of perspectives. It has implications, for instance, when it comes to the legal standard and to the question of whether the European Commission has established a breach of the law to the requisite legal standard. Right? So one interesting question in that regard is, well, can you take for granted the aspects of the ecosystem that you consider to be positive or pro-competitive? How about the bits that you consider anti-competitive? And what happens when the positive and the negative aspects of an ecosystem are closely intertwined? Can you say that the aspects that you deem negative are anti-competitive without taking into account this intertwinement and without sort of asking yourself the question of how this would affect the overall balance, or without asking yourself the question is, well, would the positive aspects of the ecosystem have existed? Would it have been possible for the positive aspects of the ecosystem to exist in the first place had it not been for the aspects that you consider to be negative, right? So that's, I guess, one interesting question that I found fascinating from a theoretical perspective. And I'm sounding too much like an academic, probably, to your audience, right? So let me be a bit more specific. Let me get a bit more to the ground and I think escape the clouds for a second. So then I would say there were two aspects that I found particularly interesting. The RSAs were more sort of garden variety exclusivity agreements, so less interesting, but the so-called MADA was quite interesting, and the anti-fragmentation obligations were really interesting as well. So the MADA, as I understand it, was the bit that made the monetization of the value generated by the ecosystem possible, right? You had an ecosystem that generated value. This had never been discussed throughout the case. And I think the European Commission, both the General Court and the Court of Justice, they acknowledged that it was an ecosystem generating value and generating competitive opportunities, even to, or above all, if you like, Google's rivals. So that was not out of question. But I think the interesting bit is that the European Commission took issue with the core of the monetization strategy, what got the ball rolling, if you like, what made sort of the ecosystem possible in the circumstances and given sort of Google's, if you like, monetization strategy. So one of the things that I always say is I think Google is an immensely successful company, but if you look at the figures and so on, Google is essentially a one-trick pony. It's an incredibly successful, one of the most successful one-trick ponies in history, but a one-trick pony nonetheless, right? So then against that background, well, you say, well, if you go after the one strategy that Google has developed and the only strategy pretty much that has developed meaningfully over time, well, can you take for granted the value generated by the ecosystem? How is the monetization strategy that it involves some form of time connected to the value generated? Can you say, well, the value and the ecosystem would have existed anyway, and Google would have developed another monetization strategy? Do we know that? How do we know that? Who has to prove that? So those were, I think, the bits that I found particularly interesting and fascinating about the case. So then this was argued in the context of the administrative proceedings, it was argued before the General Court, and ultimately argued before the Court of Justice. Do we get an answer on this? Well, I'd be curious to know your views on that as well, Alba. But as far as I can get, I think the issue, this is in part because of how issues get argued before the Court of Justice on appeal. This is because of the nature of the appeal as well in the system and so on. We don't really get an answer on that. Then I guess the crucial question was, well, what is the role of the counterfactual and how does it play a role in the analysis? So the counterfactual is crucial in the context of Article 101. We know that in the Servier saga, which was an Article 101 mainly saga, it was fairly clear. And I think the court made it explicit that the counterfactual is the mechanism by which you establish a causal link between sort of a behavior and the alleged anti-competitive effects of the behavior. If it's not for the counterfactual, you will not have discharged as a claim under a competition authority your burden of proof, right? So what we get here is something different. We get sort of a more relaxed attitude towards the assessment of the causality of the practice. And then from that perspective, the issue ultimately doesn't get really answered in the end, right? So what the Court of Justice says, and we can discuss, I think, the rationale behind the choices made by the Court of Justice, which I think is another interesting discussion, is as well, you need to establish as a competition authority or as a claimant the causal link between the practice and the effects, but the requirements imposed on the claimant or the authority do not go as far as to demand it to establish such causality in light of the counterfactual. Other methodologies are possible. And then by ruling in that way, the rationale of which, as I say, we can discuss later, then this fascinating question, I think the core question of the case ultimately gets bypassed, right? So then we don't really have anything by way of that. And then the one aspect that I personally found to be particularly fascinating, I think doesn't really get answered. And the same is true for the anti-fragmentation obligation, right? It's really interesting. And the way I have been presenting the anti-fragmentation aspect of the case is by reference to franchising agreements, right? So you think of franchising, big franchises, I don't know, large franchising systems like McDonald's, Burger King, and all the rest of it. Well, they will typically provide for a non-compete obligation. And that was essentially what was going on here. So if you pay attention to that, it was not really about fragmentation in the technological sense, at least, with the public information that I had, I was never particularly persuaded by the sort of technological dimension of the anti-fragmentation argument, but I think there was an economic rationale that I found to be interesting in the anti-fragmentation clauses, right? And why? Because it was essentially a way of saying, well, if you want to benefit from the ecosystem created by Google, so then basically Google's proprietary version of Android, then you cannot undermine the system at the same time. So it's either with me or without me. That you cannot have, if you allow me to quote, have your cake and eat it. That was essentially the rationale of the anti-fragmentation obligation. If you're with me and you want to benefit from the ecosystem created by Google around Android, then you will have to commit to me. You cannot create a rival ecosystem based on Android while at the same time benefiting from that. Essentially, it's a way of saying, for instance, in the context of franchising, if you want to benefit from the McDonald's ecosystem, you cannot run a competing burger joint at the same time, or you cannot be with McDonald's and Burger King at the same time. If you want to commit to the McDonald's ecosystem and benefit from sort of the visibility and the reputation of McDonald's, then you have to accept not to create rival value propositions. And it was sort of a relatively modest non-compete obligation in the sense that it was not an altogether prohibition on running rival ecosystems. It was simply on ecosystems based on Android. Again, a really interesting question, I think, and against all this case that we have on selective distribution and all the rest of it, one could potentially see, at least in the abstract, a rationale behind that. Again, you look at the judgment, how it gets argued, why it gets argued at the sort of objective justification stage, and all that really interesting stuff doesn't really get argued. And again, well, it's a function in the end of how cases reach the Court of Justice on appeal, right? So in the end, sort of we get some discussions. I think I have the judgment here with me. I think it was in the end mostly, as far as I can remember, on objective justification, etc. All the core aspects again about how do you understand this in the context of an ecosystem? Can an ecosystem survive if it is constantly undermined by people taking benefit on it? Or can you really get an ecosystem going when the members of the ecosystem are allowed to undermine the ecosystem at the same time? And if that's the case, well, what is the point at which you consider that the behavior becomes anti-competitive? Because I think at the beginning, perhaps you could say this non-compete obligation may have a rationale. But if you say, well, at some point in time, this rationale is no longer compelling, well, how do you draw the line? Who has to prove what? And so on. So again, I mean, another point where we have no answer. So then in the end, what we end up with, I would say, is a number of really interesting thoughts about, well, Article 102 in general and Article 102 as it applies to digital markets in particular. And this is what we're left with. And, well, we have to live with the system as it exists and with sort of judgments that we can reasonably expect from the EU legal order as it is currently designed.
You were saying about these principles that the Court of Justice fleshes out again on Article 102 and how those principles then are translated or transposed into digital markets. And I was wondering whether you have this feeling or whether from the ruling we can extract the conclusion that actually those principles are somewhat specializing or getting specialized for digital markets. For instance, the Android Auto case also comes to mind with regards to this specialization, and maybe the differentiating factor for different types of general principles applying to digital markets is not due to the nature of digital markets, but rather because they are considered as super dominant undertaking. So I wanted to pick your brains on that and ask you, what do you think, whether the Court of Justice is really reinstating this idea of renewed general principles under 102 relating to digital markets?
Yeah, and I think it's a great point. And then the one thought that I had, I mean, probably the first thought I had as I was reading the judgment is, I think, in a way, the Court of Justice reiterates something that has been with the Article 102 case law pretty much from the beginning, which is that Article 102 is the law of the exceptional. And what we can add to that is that it is also the law of the exceptional within the exceptional. That's the main lesson I draw. And this is where I think your point about sort of there being some special rules about digital markets, etc., comes in. But then why do I say the law of the exceptional is because I think if one takes the long view of Article 102 and of the judgments of the Court of Justice over time, etc., and what drives the judgments and so on, the one conclusion one immediately draws is that precedents are less of an indication about the future rulings than in other areas of the law. Right. So then the consistency, which has become almost perfect, for instance, in some areas of Article 101. So for instance, when we think about Article 101, restrictions by object and so on, the sense we get is a sense of continuity and a methodological consistency that applies sort of almost without a flaw. right? In the context of Article 102, there's always something peculiar or special about the case that might explain a slight departure from the relevant precedent, right? So from that perspective, one cannot assume that just because a similar case was decided in a particular way in another Article 102 case, that the future case or the future similar case will be decided in the same way, because there may be factors influencing the analysis. I think this is something where the court has been consistent. So then it's weird, right? So then it's a lack of consistency that is consistent, but I think it has a logic. And I guess this is the one point I would explain, right? So then it is not a random approach on the part of the Court of Justice. It is rather the acknowledgement that dominance is an exceptional occurrence in general in the economy. And to the extent that it's an exceptional occurrence in the economy, we have to allow for some leeway. So one example is what I was mentioning before about the counterfactual. So then in the context of Article 101, the counterfactual will be front and center of the FX analysis. When it comes to Article 102, well, there's a relaxation of that requirement. There's an acknowledgement that, well, precisely because we're dealing with dominance, precisely because we're dealing with an exceptional occurrence, well, the methodological approach might have to change simply to account for that. But that's the exceptional, right? I think that means that there will be something special about the way we handle Article 102 cases. This will always be the case, right? But then you have to add the exceptional to the exceptional. And this is where digital markets come in. Right? So then I guess this is where I think the Court of Justice is willing to accept the reality of some of these market thing, and just relevant paragraphs that I have here with me. Then if we look at sort of 273, 274, 275, all the way to 278 in the judgment, I think there's a way of saying, well, these markets are not like the others, in the sense that the dynamics of the industry lend towards the emergence of natural monopolies or network monopolies, right? So monopolies either driven by fixed costs or driven by network effects. And this is a reality we cannot ignore, and that has an impact on the way we acknowledge that. So there's a number of ways in which we can read these paragraphs, right? I'm sure there will be no shortage of papers in the coming months and so on, and years analyzing that. But a reasonable potential first reading of what the Court of Justice states in this passages of the judgment is that probably the court is saying, well, when we deal with markets in which an equally efficient competitor cannot emerge as a result of the dynamics of the market, well, perhaps the way the analysis of anti-competitive effects is performed will have to change accordingly. And this is where I think the discussion comes interesting. This is where I think your point comes to life, if you like, because from that perspective, the court is saying, well, I mean, dominance is already exceptional, but we are dealing with cases or with industries that come within the exceptional of the exceptional, where actually we have to go as far as to say, well, in these industries, not even inequally a hypothetical, equally efficient rival would emerge, simply because, well, the dynamics of the industry we do not allow that for that to happen. And in that context, perhaps the analysis of anti-competitive effects will have to change accordingly. And for instance, one interesting point that I think, and where the court makes the point repeatedly, has to do with the replication of the behavior. Right. So then when it comes to the equally efficient competitors and all those passages, etc., the one point that the court reiterates is about the replicability of the conduct. And I think there's little to dispute, right? So we have a quasi-monopoly or an altogether monopoly within an industry, and this quasi-monopoly or monopoly engages in time conduct. It is inevitably the case that a rival would not be able to replicate the conduct. Only the monopoly would be able to engage in time. And if that's the case, well, the court is saying, well, sometimes we will see instances where a rival cannot replicate the conduct simply because, well, it's only available to the dominant undertaker, right? And the court appears to be suggesting this is a reality we cannot ignore, right? So that's interesting from a number of perspectives. Interesting because, of course, it applies to digital very obviously, and it's a way of saying, well, in these markets, this is the world we have to live in, and this is the exceptional within the exceptional. Because, well, dominance is already exceptional, but I mean, dominance within markets where it is not easy to replicate, well, that's already really, really exceptional because these markets do not lend themselves to competition. And maybe sometimes even the markets adjacent to the dominated markets do not lend themselves either to competition, right? So those adjacent markets themselves may have a tendency towards monopoly also, right? So then the court appears to be saying we have to account for that. We cannot simply ignore that. and these are digital markets. So that's one reason why it's interesting, and I think in a way it's connected to the Android Auto judgment that you were mentioning. So then the way in which the court phrased, reframed, if you like, the refusal to deal doctrine appears to account for that, right? So it's basically saying, well, digital industries, generally speaking, see markets where services or activities or segments of the value chain are open to rivals, right? So then these models run by digital platforms are partially open and partially closed. So then the court in Android Auto said, well, because this is how they make money, because this is how they have designed their models, just to open opportunistically some segments to rivals and keeping some of them from themselves. When we see these markets which are partially open, or these activities which are partially open and partially closed, the refusal to deal doctrine will not be available. It's a way of saying, well, we're dealing with digital markets. The refusal to deal doctrine as traditionally understood would not be the relevant legal standard, right? And I think in a way, this judgment acknowledges that reality as well. So when we're talking about these markets, we're going to adjust the assessment of anti-competitive effects. It cannot simply be business as usual. So that's one interesting point. And I think it's very much connected to Android Auto, which I think by making the choice or by reframing the refusal to yield doctrine and says, well, the decisive consideration is no longer whether or not access had been given, but rather whether or not the business model has been designed as one that is partially open and partially closed, then, well, it has implications to the market in that sense. But I think if you allow me to take a longer term perspective just for a second, I think it marks a change of tune as well, because we cannot forget that the as efficient competitor test and the idea more broadly that Article 102 is only concerned with the exclusion of equally efficient rivals. This was something that was developed in telecoms market, which have the same features, right? But then in a way, what we're doing with digital markets, with the regulation of digital markets, is essentially replicate the telecoms regulation of the 90s and early noughties. And we regulated telecoms for the same reason we're regulating digital, because at least some segments of the telecoms value chain had a natural tendency towards monopoly. But what's interesting is at the time, in spite of the fact that at the time of cases like Deutsche Telekom and so on, we had natural monopoly segments, and still the court said, no, the as efficient competitor test is going to provide the basis for the legal test. Here, we're taking a different approach, right? So in a way, the court appears to be suggesting that digital markets demand perhaps some adjustments that are necessary, right? And that perhaps tells us something about the time. At the times of Deutsche Telekom and so on, say more or less 20 years ago, there was this optimism that economic and technological changes would naturally do away with the natural monopoly problem in telecoms. Here, what we see is something else. We have this sense that, well, entrenched positions in digital markets are here to stay, and that necessarily has implications for the way we apply and interpret competition.
And within this law of the exceptional that you were highlighting, so today I have been working on a piece analyzing the European Commission's specification decisions relating to the DMA and how it interprets Article 611, 67, and it provides the control in the reverse of what the Court of Justice wants to take back, in the sense that now that the DMA is operating the opening up of these markets, the European Commission is realizing that some of the control must stay with the undertakings, and now it's also within the law of the exceptional, we are also seeing a development towards the policy of the exceptional. So with that idea in mind, and taking into account that you also mentioned the development of monetization strategies and how the one-trick pony service and business model built by Google was monetized and secured through the MADAS, specifically, I was going to ask you, so the Court of Justice basically produced a finding relating to how the undertaking can use means different from competition on the merits in cases of tie-in. So I wanted to ask you, what has the ruling clarified here and what is left unaddressed in terms of how we interpret cases of tie-in?
Well, thank you. What has it clarified? I'm afraid nothing, or at
Okay.
least we can put it differently if you like, right? We can say that if it has clarified something, is that at least for a while, competition on the merits will be here to stay with us. And that's an interesting twist of events, if you like, because competition on the merits had been forgotten for a long while. If you look at the case law from, say, Deutsche Telekom, we were mentioning before, competition on the merits was nowhere to be found. We're talking about 2008, 2012, post-Denmark, etc., all the way to Intel and so on. Competition on the merits was nowhere to be found. Or if it was going to be found, it was simply as a footnote or as a formula without any sort of operational meaning. And competition on the merits was revived by dominant firms, including by Google itself in the preceding Google shopping judgment. And I think how it was conceived, I think the strategy, I think, is quite transparent, was to impose an additional hurdle on competition authorities when it comes to proving an infringement. It was a strategy that consisting of requiring authorities not just to prove the anti-competitive effects, but to prove that in one way or the other, the behavior was somehow abnormal or sort of not meritorious and therefore problematic in and of itself, right? So a way of requiring an authority to say, well, if something is a normal form of competition or something is potentially pro-competitive, it cannot be an abuse. Only a mischief, if you like, only bad behavior can amount to an abuse. So this is how competition on the merits made a comeback, both in Google Shopping and in Servizio Elettrico Nazionale. And the question we had then is, well, what is the role of competition on the merits in all this business, right? So what do we have to do with that? And then because it was revived, now I think there's this sense that we have to identify a role for competition on the merits. And the judgment, in a sense, appears to be insisting on an idea that was already present in Super League, that was already present in Google Shopping and so on, whereby there's in principle two components to an abuse of a dominant position: a practice that departs from competition on the merits and a practice that has anti-competitive effects, at least potential ones. So then we are left with the question as well, how do we prove that a practice departs from competition on the merits, and what do we mean by competition on the merits in the first place? Then I don't think the judgment is particularly illuminating in this respect, other than to say, which is quite interesting, that seemingly tying by its very nature appears to depart from competition on the merits, which I think was a thesis advanced by Fernando Castillo in some of his writings. So there's this idea that tying departs from normal competition insofar as it involves an extra obligation imposed on the customers of the dominant firm. So it's basically the dominant firm forcing its choices on the customers. And for that reason, it would depart from competition on the merits. So this is what we're left with, but I think we don't really know much other than that. One thing I would say, and in particular in digital markets, is that the discussion of whether or not something falls within the scope of competition on the merits will be a big bone of contention moving forward. Because I think if you combine all of the factors of the judgment, the fact that the analysis of effects that will have to be adjusted to the features of digital markets, the fact that a counterfactual assessment is not going to be the only methodology by which a causal link between the behavior and the effects is established, and competition on the merits, well, is pretty much the core question that will be relevant in digital cases, right? Because I think the one sense you get is that, well, sort of the analysis of effects will have to be modulated in one way. And that means that probably the only fight in many cases left for the dominant undertaking is whether or not something falls within the scope of competition on the merits. And against that background, how do we make competition on the merits operational? I think German scholars in the 1950s already concluded that there's no way to make competition on the merits operational. Are we going to square the circle? Are we going to find the philosopher's stones now in 2026, 70 years plus later? I don't think so. I mean, you know what I think, etc. My views on this have been already open, but I think it's an interesting discussion in many respects, right? Then the digital, one of the most cutting edge sectors where dynamics are complex, etc., is going to be assessed against a legal technology that we thought was obsolete in the 1950s, right? So there's an interesting paradox from that perspective, that sort of we're going back to the 1950s and to something that had already failed in the 1950s, and on that basis, we are trying to pretend that we're going to be assessed the legality of conduct of the 2020s, right? So then, as I've always said, good luck with that, right? So then does it make sense to do that, I think? And do we even have a set of criteria to draw the line between competition on the merits or not? I don't think we do have at present, and I don't think we will have those at present. So this is one of the open questions left with Andre.
So you were talking about this philosopher's stone, how we cannot make competition on the merits operational. And I was wondering whether we can, in the end, have an enforcement applied to digital markets which can be operational, bearing in mind concepts such as ecosystems. And you were talking about the complexity of how we define those, and maybe some of the faults of incorporating those into competition law come from basically the economics underlying it, which aren't quite clear about how to differentiate these different advantages from the disadvantages created in terms of competition. So I wanted to ask you, how does Google Android approach this dilemma of factoring in competitive effects generated by conduct taking place in ecosystems vis-a-vis the anti-competitive effects that follow, from instance, from operationalizing monetization strategies within the one-trick pony of Google's business model? How do you think about that?
Well, that's great. I think, it's pretty much in line with what I was saying before, in the sense that the fundamental issues get bypassed, right? Because when we think about ecosystems, we have to ask ourselves, what is it that keeps the ecosystem alive and kicking? What is it that made the magic, right? Because I think one of the things we need to bear in mind when we think about Android and the past, etc., is that a lot of systems fail. And when we think about killer acquisitions and the rationale behind the acquisition of startup companies and so on, is that sort of funding or finding an idea is often the easy part. The monetization strategy is the more difficult part of all of that. And very often what we see in the startup ecosystem is, well, we have a great idea, we don't know how to monetize that. Well, we'll worry about the problem later. If you think of companies like Uber, etc., well, you have the idea, you sort of enter aggressively into many jurisdictions, many local areas and so on. And so we'll think about making money later. For the time being, we're going to burn private equity money for as long as we can survive and so on. So that means that the monetization problem is a core one and is one of the key drivers of many of these acquisitions in the digital industry, etc. But I guess the one point I would make in that regard is that a sort of competition law cannot take it lightly. Right. So then from many perspectives, so when it comes to looking into mergers, when it comes to Article 102, etc., there's not something that can be an afterthought. I guess this is the one big lesson. And the Android, in a way, doesn't address that, because I think how it was argued, etc. So then one of the interesting points moving forward is that, well, these issues may be relitigated. We may see the issues that in the end were not addressed head on in Android, they may go back, right? To think about the causal link. The one thing that has survived about sort of the orthodox analysis of anti-competitive effects is the causality. Right? The monetization point may come back in discussions about causality, right? So then the authority says, well, your behavior is causing anti-competitive effects, but then you say, well, no, these anti-competitive effects are caused by something that has nothing to do with what I'm doing, or the anti-competitive effects. It would be worse in the absence of my behavior, for instance. So there's something that might come back, and this is where the monetization strategy may come in, right? If you allow me to be more precise, the Court of Justice comes to the conclusion that the counterfactual may not be the only methodology that you use to establish the anti-competitive effects. But what happens if there's a methodological dispute between the dominant undertaking and the competition authority? Reasonably, the competition authority, on the basis of the judgment, may claim, well, I cannot be required to rely on the counterfactual. But what happens if the dominant undertaking comes and says, I have run my methodology, and on the basis of my methodology, actually, your analysis is flawed. I have relied on the counterfactual, and my counterfactual is telling me that thanks to my monetization strategy, that there's more competition than there would otherwise have been. And this is not an analysis of the pro-competitive effects, which is another point I think rightly the Court of Justice mentioned, is simply to say, well, in a world without my monetization strategy, there would have been more anti-competitive effects, right? So what happens if a dominant undertaking, even in the digital sphere, comes up with that? And there's a methodological dispute, right? Like the ones we saw in cases like Qualcomm, right? Where, if you remember, in one of the Qualcomm cases was in the end the dominant undertaking that prevailed. It says, well, in principle or in theory, a dominant undertaking may establish the abusive nature of loyalty rebates without relying on the AAC test. But then what happens if sort of the analysis of the authorities is rebutted on the basis of the AAC test? We saw that in Qualcomm. This is where the monetization strategy may come back with a vengeance in a cases like this one. There's this methodological dispute that there was in Intel. Say, well, your analysis says A, but I'm rebutting your analysis on the basis of B, which relies on the counterfactual, and says, well, actually, this is what my sort of business model is allowing to happen. So those are questions that in a way may come back. And one reason why I was saying we may not take, or we should not take, so the business models lightly, right? The other big question is about competition authorities are not becoming sort of managers of digital undertakings, right? Because I think we have to acknowledge that finding an abuse when the case goes against the heart of a company's business model might require the dominant firm to change its business model altogether, right? And again, this is a question not to be taken lightly. So then, is competition law in the business of remaking the business model of dominant undertakings? How often should we do that? I think this is an interesting question, right? So in a way, I mean, you were mentioning the DMA and so on. I think in some cases, the DMA is challenging the business model of companies and is there to question the business models. But I mean, in a way, the DMA, I'd be curious about your opinion, but in a way, the DMA was open about that, right? It was never making a secret that part of the appeal of the DMA was to alter business models and so on. And it has democratic legitimacy, if you like, because of that, because I think it was an open legislative process, which from the outset was saying, well, we're going to question that. In principle, the European Commission was given the resources to do that, right? So when it comes to Article 102 and competition law more generally, well, we have to think about that. Because I think, in a way, Google is such a profitable company and such a success story that you could say, well, it didn't make much of a difference. But sometimes it could make a difference, right? You could say, because I think what we have to bear in mind is the aftermath of Android. The analogy that I use is that between free-to-air TV or pay TV, right? So then essentially Google was following a free-to-air TV model, like the typical commercial TV channel that we know, an advertising-based TV channel, which has a business model built around a two-sided platform whereby the advertisers were financing the system and the consumer will get access to the content for free. But I mean, after that, it said, well, you cannot monetize in this way, or this monetization strategy in itself, by its very nature, is anti-competitive. And that means that you have to change your business model from being, say, ITV here, or I could say Antena 3 in Spain, or I don't know, CBS in the US. Now you have to become Netflix. So that's quite interesting. So then it's essentially competition law forcing a company to go from sort of being CBS to being Netflix. So then that has implications. In the same way, I'm going back to Android Auto. I mean, if you think about the implications of that, that was quite significant if you think about it. It's saying, well, actually, absent exceptional circumstances, leaving the design of the platform to the dominant undertaking, we're going to a world in which sort of the business user of the platform gets involved in the design of the platform. So here is pretty much the same thing. We're actually, from Article 102, leaving the choice of the business model to the dominant firm and not really messing with the business model. If we start to say that some strategies that allow for a particular business model to occur can be considered to be inherently anti-competitive, well, we're essentially telling companies, well, sometimes you will have to overhaul your business model altogether and find a new way of making money. I'm not saying this can never happen. I think competition law has a pedigree in that area, so this has happened in the past. But I think the question we have to ask ourselves is, how often do we do this? On what basis? And what are the principles are we going to follow when doing that, right? So in the past, in the old days, I think long gone now, of McGill and IMS Health and Bronner and so on, well, that was essentially changing the business model of a company, saying, well, from a model based on vertical integration, now you have to switch to a model whereby you monetize by licensing or by giving access to third parties. But it was sort of circumscribed to exceptional circumstances. Now, the melody, if you're hearing, is one that is quite different, right? We're saying, well, this will happen more often than it used to be the case. This will not longer be confined to exceptional circumstances. This may happen more often than in the past. Well, if so, on what basis, on what principles, and have we thought about the consequences, right? I think Android Auto is another judgment where we have plenty of potential implications in terms of what it means from the perspective of the resource of an authority, because co-designing a product and sort of being the referee of the co-design process between the business user and the dominant undertaking is going to be resource consuming, etc. Well, how do we do all of this? Well, I guess we'll have to accept at least that it is going to be difficult, and the difficulty, I think, will be compounded because of private enforcement. Because, well, one thing is to have a highly expert authority like the European Commission with the resources and with the expertise developed over a decade now in digital markets, etc. And it is used to a dialogue. I think even the DMA itself is a way of obtaining input, and some from dominant firms engaging in this regulatory dialogue that sort of gives the European Commission a sense of how a particular sector operates. And a completely different story is to entrust a judge, no matter how expert, with all of those complex questions. And then how do we handle all of that? And what gives us the certainty that sort of by finding an abuse, we're not making a whole business collapse simply because another business model is not a possibility, or another business model is something that for whatever reason is beyond the capabilities of a dominant undertaking. And this is where the one-trick pony point that you mentioned is quite crucial, right? So then it's not because one digital firm is a successful, an immensely successful one-trick pony, that it can sort of happily venture into other ways of monetizing, right? So maybe sometimes it fails altogether, right? And then we'd be faced with a paradox of saying, well, by trying to protect competition, a whole ecosystem may no longer be viable, or even if it's viable, it may no longer be as vibrant as it used to be. But then none of this is to say that we should enforce competition law. It's simply that this requires sort of a thought process, I think, carefully thinking through, and how do we do this, right? Are we going to say, well, enforcement and prioritization and administrative discretion is going to be the way to do this? And says, well, we're going to trust the instincts of competition authorities not to go too far when questioning business models. This leaves the private enforcement question unresolved, right? Because even if we say, well, competition authorities are going to remain reasonable, and I'm happy to accept that, I mean, don't get me wrong. But then, of course, this gives big incentives. So judgments like Andrew Otto give big incentives to private claimants to go to a court and say, well, let's see how far we can go in sort of changing the way a sector operates. And then that gives you the answer. And if we're going to say, well, prioritization or administrative discretion is not going to do the trick alone, it's going to be unreliable and leaves the private enforcement issue unresolved, as I was saying, well, we're going to use the law. We're going to use the law to develop legal filters just to make sure that we intervene when it makes sense to do so. And sort of we acknowledge at least, or we have the law or a legal set of rules that acknowledges at least the difficulty of the issue. Well, how do we design those? On what basis? I can tell you that I'm pessimistic about competition on the merits doing the trick.
Okay, and on that last thought, first of all, I would like to thank you, Pablo, on the open question on whether the DMA really didn't hide its intentions with regards to doing the same that maybe now Article 102 intends to. I think that the remedies were there and readily available for the legislator and now the European Commission as an enforcer, but I don't know to what extent the regulatory targets, the gatekeepers, expected enforcement to take place in this manner, specifically with regards to how the European Commission is now applying the obligations, because it's a wider exercise that we expected, because the obligations, okay, they come from cases that we already saw, but it seems that legal standards are not so relevant here, and what's relevant is actually interpreting an obligation building on that administrative discretion that the European Commission has in the widest way possible to try to accommodate different interests. And I don't think that was unexpected on the side of the gatekeepers, and that was then going to serve as a channel to try to impose directly additional measures and additional obligations on gatekeepers, for instance, through specification proceedings. So I think that the DMA is now conforming itself as a really big monster that these undertakings are going to challenge, and now they are going to face, specifically in the courts, and as you said, also with regards to private enforcement. So how is that going to play out? Because I am quite uncertain how the DMA is going to take part and to be applied before the national courts. We had these problems with competition law already, that national courts didn't really know how to accommodate competition law into their national regimes. And now we say, okay, now there is an additional layer of complexity. The DMA comes into force, and now you have to maybe read an 132-page specification proceeding, providing all of the technical measures that, for instance, Apple has to comply with regards to vertical interoperability, and you have to be able to understand that and understand that this is a completely different creature as opposed to competition law. So I think that the expectations are quite high on that front. But with that, and if you don't have anything more to add, I just wanted to thank you, Pablo, for joining us here, sharing your thoughts on Google Android, and for the audience. So if you like the video, don't forget to subscribe, to like, and to rate this video. Also include any comments below. And yeah, thank you so much, Pablo, for joining us here in the Agora.
Thank you. Thank you so much.
Bye-bye.